You're good? You're ready? When you want. You're ready? Yeah. Attorneys, are you ready?
Yes, thank you.
Law clerks, are you ready?
Yes.
Yes, I'm ready. Court, all rise, please. Danny. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Okay, thank you very much and good afternoon. We only have one case on. This case has been rescheduled. I hope everybody's feeling well and glad to see everybody here today. The case number is 2022-0754, Children's Health Rights of Massachusetts, Inc. versus the Cambridge Public School District. Ready to go. Actually, I'm going to stop you for a moment. I realize it must be because of the afternoon. I should introduce the panel before we begin the argument. I apologize. To my right is Justice Mary Sullivan, and to my left is Justice Sabita Singh, and my name is Ariane Vuno. Each have 15 minutes for your argument, and there is no rebuttal. So I think I've covered all the intro. Go ahead.
Thank you, Your Honor. Members of the panel, may it please the court. My name is Brian Unger, and I represent Children's Health Rights of Massachusetts, Incorporated. It's a nonprofit organization of parents and students that are opposed to the imposition of various COVID-19 related mandates in schools. Here, of course, being COVID-19 vaccine mandates by the school districts of Cambridge and Belmont. So first, the one issue of primary importance I want to address is that school districts are not statutorily empowered to create health rules for students, nor can that power be read into Chapter 71, Section 37H. Health rules.
Counsel, before you get to the merits of your argument, I think
Sure.
it would be helpful for the panel because there's a standing issue has been raised, so
Sure.
we only get to the merits if we get to standing. And I apologize for interrupting you so early in your argument. Usually I like to let people go a little longer, but This is critical.
Of course.
As I read your complaint and the other materials, there's no allegation that either the nonprofit or any of its constituent members have actually been harmed. Have I suffered any actual harm? Nobody's been kicked out of a program. Nobody's been vaccinated against their will. Is that correct?
As far as what's alleged in the complaint does not allege that anybody has been kicked out of a program or been vaccinated against their will. Correct, Your Honor. But I would disagree that there is no harm that has been suffered, especially under the Section 2 GLC 2231A, which states the right, duty, or status of or other legal relations under deeds, wills, contracts, or writings constituting a contract under the common law, statute, municipal ordinance, bylaw, or administrative regulation, including the determination of any question of construction or validity thereof which may be involved in such determination. That is the declaratory judgment statute.
Well, that clearly gives the court the authority to make such declarations. I understood your brief to say that it was your understanding that where a constitutional issue was raised, no showing of actual harm was required.
Well, and as far as constitutional issues, Your Honor, that is correct. Well, rather, there is a presumption of irreparable harm in that case.
Do you have any case law to support your claim that you don't have to show actual injury, as we understand it, for purposes of standing in a constitutional claim or under the declaratory judgment statute?
I would just argue on that point, Your Honor, that a legal injury or that injury to rights is enough of an injury to give you standing to have your rights determined as between you and another party. So here that would be the students and the districts, in much the same way as the Declaratory Judgment Act is often used between two parties to a contract.
I understand your argument. I'm asking you if you have any case law that supports that argument.
Just all I would say to that, Your Honor, is, for example, in Doe versus Secretary of Education, and I apologize, I don't believe this was in the briefing, that's 95 Northeast 3rd 241. That's SJC opinion from 2018. It just says first that the questions of whether actual controversy and standing exist are closely related in actions for declaratory relief, and also that in declaratory judgment actions, both requirements are liberally construed. So to me, that just, I interpret that as being, so long as there are two parties who have a dispute over one party's exertion of authority over another, that party should have standing, at least to have the court determine whether or not that action is permitted and is legal.
So while you're saying that there's no allegations in the complaint regarding any particular, let's say, injury or harm having already taken place, the argument is that it's threatened to take place if the mandate is imposed.
Well,
on the individuals.
Yes, Your Honor, and the mandates have been imposed, at least in Cambridge, the mandate is still ongoing. And there are other harms beyond just the legal injury. I mean, it's coercive. We argue that it's coercive. There's really no, at this point in the pandemic, if it's, still ongoing, there's really no point to mandate these vaccines. From what I understand, they respond to, or rather, they were developed for the original strain. That's, I'm not a scientist. I'm not trying to claim, many scientific facts here, but it's and frankly, there's risk. There's risk involved in taking it. I think at this point, that's been widely acknowledged. So if there's any coercive measure at all to try to mandate anybody should take these, I believe that is harm. It's it's a coercion that can potentially cause somebody harm, either if they take it and then suffer an injury, or if a student, for example, just decides not to participate in any extracurricular activity. Perhaps a student will not play sports, not join an after-school club because he or she doesn't want to expose himself or herself to the administration as somebody who, is against their policies.
And your position is that that doesn't need to be specifically alleged in the complaint, that somebody has decided not to participate in something because of the mandate?
Of course, it would be helpful if it was.
Well, let's say if we decided that that needed to be more explicit, would you be able to amend your complaint to allege those things?
Absolutely. Yes, Your Honor.
So we'd be back here?
I'm sorry?
So we'd be back in this position at some point?
Well, probably not arguing standing at that point. So it's our position that the legal injury by itself is enough here to give standing for purposes of declaratory relief.
Okay.
And further, I mean, there are cases where, they say standing is hypothetical or too remote. One case is the 10 persons of the Commonwealth versus Fellsway Development. In that case, it was nearby property owners challenging the development in the Middlesex Fells Reservation, but they weren't actually in the district. They just had an interest in seeing that, they had an interest in the historic value of the park. They weren't really a party that was even conceivably affected by it. The Tax Equity Alliance case, it was a group of citizens challenging a new system of capital gains tax that didn't even apply to them. Their theory was that overall it would cause the Commonwealth to lose tax revenue that they as taxpayers would have to make up somehow. So I mean, I think the relationship is much more clear here between the students and the school. And the fact that it is alleged in the complaint that the students attend school at the districts and are subject to their rules, and that further it's alleged that these rules are illegally created, they have standing to have their rights determined.
Let me ask you this, if we go beyond the standing issue, I understand that there was a motion to strike the affidavits that were offered. That motion was not ruled on?
And I apologize, Your Honor. I don't believe so. I don't believe it was ruled on. I may be wrong about that.
So would we be in a position to rule on the merits, or would it need to be remanded back for findings by the trial judge?
On that issue, Your Honor, I think just because, well, if the court finds that there is standing here, I think the legal issues are presented well before the court, and that the court would have enough information there, just on the statutory law, just on the preemption issue, to issue a ruling, if, of course, you find that there is standing. Mm-hmm. So if I may address those arguments, unless there's another standing issue or question. So as I had begun to say, this authority has to be read into the statutory section. It's not there. It doesn't say you can create health rules for students. And so there's this argument that school districts have broad authority over their schools. And certainly cases say that, but in the cases that are cited, it's truly, there's a much closer connection between the authority asserted and the rule. In the Doe versus Superintendent of Worcester, it's a case where a student was expelled for bringing a lipstick knife on school grounds. That kind of student behavior is actually tracked directly back to the statute. It prohibits students from bringing weapons onto school grounds. Leonard versus School Commission of Attleboro, it was a case excluding a student due to violations of the dress code for having an extreme haircut. That was back in the 60s, I believe, was a male student who came to class with long hair. Hammond versus Hyde Park, I know that is one that actually does deal with infectious disease. However, in that case, the local board of health required a smallpox vaccination, and then the school district required a revaccination certificate. But it was not the school district itself that imposed the rule. Okay, so I just want to be clear that it's our position school districts do not have the authority to impose health rules and do not have any emergency health authority. To the issue of preemption, General Law, Chapter 76, Section 15 clearly states certain immunizations that children must have to attend school, and leaves the rest, and I quote, such other communicable diseases as may be specified from time to time by the Department of Public Health. So, the districts refer to this as legislative silence, but I think it's actually quite clear that this only leaves the remaining vaccinations up to the Department of Public Health. It does not say by the Department of Public Health or any other government agency or branch of the government that may also have control over schools. And as I alerted the court recently, this case it's almost the exact statutory scheme as in Let Them Choose versus San Diego Unified School District, where the California legislature very similarly has in their statutes certain diseases that children have to be vaccinated for, and it leaves the rest of the California DPH. And further in the regulatory section, 105 CMR 220-500, it says that students, no student shall attend a preschool, elementary school, or secondary school program without a certificate of immunization documenting that the child has been successfully immunized in accordance with current department immunization schedules. So that too does not leave any door open for the school district to come in. So in the first instance, the school districts lack the statutory authority, but also it's preempted by the legislature. And there's also an argument in there that somehow this falls under home.
What's your best case for the proposition that the statute preempts? In other words, that the statute is a ceiling and a floor, and that school districts cannot add additional requirements?
Your Honor, I would say that in a case Molinari versus City of Boston, I don't believe this was cited in the briefing, the SJC said that a school committee is a board of public officers whose duties are prescribed by statute. And in execution of its duties, the members act not as agents of the municipality, but as public officers, which was going to bring me to my next point, that it's really not a home rule issue here. School district rules are not the same as ordinances or bylaws of a city. Those are passed by a council of the city. These are just rules that are passed by the school districts, and that the school districts are creatures of state statute. They cannot claim that they're enforcing or that somehow their authority is under home rule, and that they can add to a state statute if theoretically the door is left open.
Counselor, I'm sorry. Did you indicate that there was, the case you just mentioned was not in your brief? Is that what you said?
Correct, Your Honor.
Well, could you give us the name of the case and the site, please?
Molinari versus City of Boston.
Molinari as in M-O-L-I-N-R, okay.
Yep. 130 Northeast 2nd, 925.
Okay, you don't have the mass site? That's okay.
I apologize, Your Honor.
I'm sorry, go ahead.
Yeah, that's all right.
Looks like I'm over time, Your Honor.
Yeah, you are, and nothing.
Any questions?
Not seeing any
Any further
follow-up questions. Thank you very much.
All right, thank you.
Okay. Good afternoon, Counsel. So you'll be arguing for 10 minutes, is that correct?
Yes.
Thank you.
Thank you, Your Honors. This panel was correct right from the start by saying that the issue here, the first issue we have to look at is standing. And your review of this case can begin and end with standing.
You shouldn't assume anything from the question.
Of course. But I do direct you to look at the standing issue, because here, the plaintiff is an association and has to have associational standing, which requires at least one member to be able to have standing to bring suit on their own right. And the plaintiffs do not have that. They have not alleged any harm whatsoever. The closest they've come is at page 14 of the appendix in the complaint to allege that the members have students who attend schools in Belmont and Cambridge. They do not allege that their students were age qualified for the vaccine at the time.
When the complaint suggests, when the complaint alleges that they're subject to the mandate, doesn't that imply that they would they're under threat of the mandate? So that would imply that they're age eligible.
Respectfully, no, it doesn't. They need to have alleged a harm that is more than speculative and remote. They need to have alleged a particularized harm. The plaintiff cites to the Villages Development versus the Secretary of Executive Office of Environmental Affairs case, but ignores that that case says there are 4 necessary prerequisites to bringing a Chapter 231A declaratory judgment claim. There has to be an actual controversy. There has to be a standing, which requires an injury in the area of concern. The necessary parties have to be joined, and the available remedies have to be exhausted. In that case, the plaintiff was injured because the Secretary of Environmental Affairs' decision restricted their ability to have access to their property, which was an actual injury on their investment-backed expectation. Here, the plaintiffs have not alleged that they, as I said, were age eligible, that they participate in extracurricular activities, that they were denied participation because they weren't vaccinated. They haven't even alleged whether or not they were vaccinated. They haven't alleged whether they've applied for one of the available exemptions. The plaintiffs try to differentiate themselves from the 10 persons of the Commonwealth versus Fellsway Development case. And in that case, they say the plaintiff in that case didn't have standing because they were, the case had to do with a piece of property in the Fells that was not the plaintiff's property. However, in that case, what the court said was that just a generalized harm common to everyone isn't sufficient for standing. Plaintiffs say that they actually have children in the district, so they're different from that case because their children could be harmed. And they say that they would be more akin to that case if they had children in some other district and were bringing this claim. But the Fellsway case says you have to actually show an injury. And
The injury could be a threatened injury, right?
it can if it's clear and imminent and not remote and hypothetical.
Well, if the rule says that you'll be excluded from extracurricular activities if you're not vaccinated, that seems to be a pretty, there's no discretion really involved in that, right? I mean, isn't that a clear, imminent harm?
No, Your Honor. There are exemptions available if they qualify for a medical exemption or a religious belief exemption, or in the case of Cambridge's policy of special needs exemption. They have, and that also goes to the fourth prong for bringing a declaratory judgment claim, that they have to have exhausted available remedies, and that there's no allegation in the complaint that they've applied and been denied.
Right, but if you don't, if you're not in that category of a religious exemption or a medical exemption, but you still have reasons for not wanting to take the vaccine. So,
Well,
you wouldn't go down that route. You wouldn't go down the route of applying for an exemption when you know you don't fall into those categories.
Well, that's not the facts that are before us here. We don't have any allegation as to whether they were vaccinated or not vaccinated, were denied participation in activities or not.
So can I ask you this, how, if it's in effect, how does the school actually determine whether somebody can join the football team or go to a school dance or be in the high school musical?
And I don't believe that's all fully developed in the record, but each school has had a process in place for getting that information from students and making that determination. But as to the details of the process, that's not in the record. I can't speak to that.
But I guess I'm wondering that if it's sort of a, if you want to sign up for the high school musical, does the director of the program say, show me your medical records? Or is it an honor system?
No, I do believe, speaking to the Cambridge system, that there is an administrative process where a student would have to provide some, backup materials, and that determination would be made by certain administrators. So it's not an honor system. They are asking for documentation. But again, that wasn't fully in the record, and it's not necessary because here, this complaint would be subject to dismissal for lack of subject matter jurisdiction for not making these bare, basic allegations of any harm.
Well, I guess I'm wondering about the situation where I guess the Cambridge and the Belmont are phrased differently, right? The Cambridge states that everyone must be vaccinated, and then there's sort of a consequence for not being vaccinated, but the consequence only goes to extracurriculars, right?
Correct.
But you're saying that a student would have to be, I'll use the term rejected from an extracurricular activity before that student could demonstrate harm.
Or have it be imminent and clear that there is about to be harm, that the student has signed up for an extracurricular activity. Here, we have no allegation other than they go to the school. We don't know, at the time of this preliminary injunction motion and hearing, vaccines were for ages 12 and up. We have no allegations in the complaint as to what age the students were, if they previously participated in any extracurricular activities, or if they were now seeking to participate in any extracurricular activity.
Okay.
Well, I'm curious, what if, since the Cambridge mandate indicates that all students must be vaccinated, say that there were no consequences. It simply stated that they must be vaccinated, okay? And nobody was ever excluded from school because of that, but it's still there. Are you saying that because nobody was excluded from school, nobody could challenge that? Nobody would have standing to challenge that requirement?
No one would, correct. I don't believe anyone would have standing. And if you look at the Tax Equity Alliance case and the AFSCME-SEIU case that are cited in the briefs, the court talks about not wanting to infringe on another branch of government's decision, but acknowledging that if there is standing, that's how they're going to provide someone with a remedy. So it's not that a branch of government is untouchable, but there needs to be an actual injury before the court should intervene in another branch of government's policy and rulemaking.
So you could have a rule that could, let's say, the rule is only natural-born or only people who are born in America can attend the school. You have that, but you don't do anything about it. But nobody could challenge that.
There has to be some type of harm, and for that hypothetical that you present, the harm may be different, but here the harm would be exclusion from the extracurricular activities. That's the remedy.
Isn't there a harm in having something there that would sort of chill that person's, attendance, knowing that there's a rule? There's a rule. They're not doing anything to me, but I am prohibited. I'm, frowned upon at this school.
And again, I think that scenario can be differentiated, and a student may suffer some type of harm from that being in place, whereas here, the policy specifically says the remedy is you can't participate in extracurricular activities, and no one has alleged that they have been denied that.
Okay. Follow up? Follow up. Thank you very much.
Thank you, Your Honors.
Good afternoon. May it please the court, Nina Pickering Cook of Anderson and Krieger on behalf of the Belmont School Department. Now, the focus of my argument is the claim with respect to Belmont is moot. However, before I get to that argument, I must emphasize that the Belmont School does firmly believe that if this court were to reach the merits that we strongly believe, it must affirm the Superior Court's decisions for all the reasons stated earlier by Ms. Baer. I would also like to say on this standing issue, I do believe it is helpful to reframe this as the appellants are complaining about harm due to a policy. The policies are in place, are not a vaccine mandate, period. They are a vaccine requirement with certain exceptions. Until the appellants can show that they have been harmed by that policy in toto, then they don't have harm sufficient for standing. And that would include the application of the exemptions within the broader policy. It's not just the vaccine mandate, and I do think that makes a difference with the standing argument here. Now, I think it is beyond
Could I ask
dispute.
a question to follow up on a question that Justice Singh had? If someone does not fall within any of the exemptions, they're not going to apply for exemptions. Let's say it's somebody who doesn't qualify for a medical exemption or a religious exemption. Your point of view would be that person, that student would have to be prohibited or precluded from the extracurricular activity, and that has to be alleged, and that before there's sufficient harm to challenge the policy.
I think there are two levels here. I think at the very least, there needs to be an allegation that they do not fall within the exemptions so that there is harm, period. I don't think the court needs to go further than that. There has not been any allegation here that they fall outside of those exemptions. So I think it fails on that initial review. Now, I think it's beyond dispute that the claims against Belmont are moot. It leaves nothing for this court to adjudicate where the appellants have complained about the vaccine policy put in place by the school committee in October 2021. That policy was suspended in
But it was specifically not rescinded, right?
It was not, and I will get to that. So it was suspended in August 2022, given that it was decided it was no longer needed, given the data that the district had in front of it. The policy they complain of is no longer in force. There's no longer any personal stake in the outcome. So I think it's beyond dispute that the controversy is moot at this point. Where the appellants go with this is if they've argued that the court should nonetheless reach this, the merits of the Belmont claims because of the mootness exception known as capable of repetition yet evading review. And the focus of that really is on this differentiation between suspending the policy and rescinding the policy. As the saying goes, though, I think that's a distinction without any real difference. Both a suspended and a rescinded policy can only be reenacted through a public process and vote of the school committee. So this is one, if it's suspended, it just doesn't magically appear again unless voted on by the school committee. Looking at the school committee minutes from August 2022, which can be found at Appendix 402 to 403, I believe there may have been a concern about the term rescinding the policy as being indicating that perhaps the policy was inappropriate to begin with, given that the policy was being challenged in this case, so that folks were more comfortable with voting to suspend it. But in doing so, even in those minutes, they acknowledge themselves that there's very little practical impact between the difference of suspending a policy and rescinding a policy. Now, this very same argument was brought up by challenge to the governor's mask mandate in the case, the City of Lynn case. And in the City of Lynn case, this very kind of same thing happened. By the time they got to the SJC, the mask mandate had been rescinded in that case. The appellants argued that it was capable of repetition and maybe evading review when these policies can be enacted and then rescinded and enacted and rescinded. And the SJC threw out that argument on the basis that just because a policy may be reenacted again doesn't mean that is just too speculative and doesn't mean that it's capable of repetition in these particular factual circumstances, particularly where the response to COVID has been such a dynamic process, and it certainly is not evading review, where the courts have dealt with a lot of these COVID challenges very quickly. I see my time is up.
Just going to interrupt and let you know that your time is up, and I'll just check with the panel to see if they have follow-up questions, and we do not. So thank you all
Thank
very
you.
much for your arguments. We'll take the case under advisement. Court's in recess.
For all rise, please.